we want to learn how do we protect all that innovation that's going on. So I'm going to turn our virtual stage over now to William Cole and George Carrera. They're with the firm Amin Talati Wasserman, and they're going to give us an update on using patents and trade secrets to protect innovations in this space. So welcome. I will turn the stage over to you now, George.
Well, good morning. As introduced, I'm with Amin Talati Wasserman in our Chicago office, and we are a food and dietary supplement firm, which, among other activities, specialize in intellectual property. So I'd like to share my screen with you at this point and talk about our topic today, which is using the instrument of intellectual property, specifically patents, and then how that will compare and contrast with trade secret protection that's available in the mental wellness space. And of course, we're targeting supplements, in particular, functional foods, prebiotics, probiotics, and other types of products. What are the different types of intellectual property that are available to applicants? We have patents, trademarks, copyrights, and licensing, all of which our firm is engaged in. And then the opportunity is always there to hold your precious and valuable trade secrets confidentially in-house. And the archetype of that is the Coca-Cola formula. And William will get into that a little bit, the aspects of details of trade secret protection. But let's talk about patents for a moment. Our basic requirement include the laws and the rules of the U.S. Patent Office. The first one being eligibility. And you may have heard this in popular press, because ever since the Human Genome Project was completed, there are restrictions on patenting DNA or organisms which are derived from DNA materials, and inclusive of DNA diagnostic tests. So it must be genetically modified in some way to be patent eligible. And this the scope of this has fanned out in the Patent Office's interpretation to include natural materials or botanicals, anything that's natural. So that's a hurdle that we need to deal with. But that might be overcome with formulation, which I'll refer to shortly. But other requirements, your invention must be new or a novel idea. It must be useful. Usually that's a lower hurdle, but keep that in mind, that it has to be something that's useful in the marketplace, useful for human application or pet application as well. And then the higher hurdle may end up being a non-obviousness standard, which is it something that, if you looked at it in terms of other products, would it be obvious? In other foreign countries, we talk about the idea of having an inventive step. So you don't want to lack an inventive step. You want to be a non-obvious in contribution to the market. What about mental wellness, and how can we apply that to products that some of the viewers might be interested in developing? Our firm has been involved with ashwagandha as a natural material, which can be used to develop extracts or even semi-synthetic derivatives. And we've worked with our clients to identify methods of using ashwagandha or formulations thereof. L-theanine, we know that this is another adaptogen which provides clarity and mental alertness. And for example, we assisted a client in developing a chewing gum formulation. Mushrooms, which we know have benefits not only cognitively, but potentially in the immune system and in the gut, in the GI applications. Extracts and blends of the same. So classes of patent protection might include compositions of matter, but don't forget methods of making those, which might be a useful way to protect yourself or gain exclusivity in the marketplace, put barriers to entry out there, and then methods of use, which are highly valuable, and in particular because of the decisions in US patent laws, sometimes are the best way to protect your market. Let's talk about the comparison of patents versus trade secrets. Now, if we look at the left column, patents, of course, protect inventions, and we talked about some of the requirements of those, right? I briefly reviewed those. Keep in mind that you have limited protection or a limited span of exclusivity, and it's pretty much the international standard. That's 20 years of exclusivity once you receive your patent. So you may get a little less than 20 years because you're working on securing those patent rights over 2 to 5 years. And so the costs that are involved involve preparation of the documents and maintenance, and then the willingness to perhaps enforce those legally, enforce your rights. So think about those aspects. And then how about how solid are these rights? And what are your competitors thinking about? Well, they're thinking about filing patent applications, and the US has a first inventor to file system. We just loosely call it first to file, but it's the first inventor. You have to genuinely be the inventor of something new. And then you can have that challenged. It can be designed around. Others can publish things in advance of you or be on the market. How about your own activities? Well, you can publicly use the invention or sell, and in the United States, you have a 1-year grace period. So that's an advantage. In other parts of the world, there's no grace period. You have to be careful about divulging things before you apply for a patent application. So one good technique is to file a US provisional application, which is never published, but it provides a patent filing date and gives you some built-in rights or protections for a full year. And then after that year, you can apply for what's called the full application. And then the 20-year clock starts ticking on exclusivity. Keep in mind that if you file a patent, then you're going to forego the trade secret route. And then the trade secret will be dedicated to the public after the patent exclusivity has run. So let's talk about trade secrets for a moment, just as an introduction. So this is anything that you don't want your competition to know and might be closely held and maintained, but you need to make an effort to maintain this, and we'll get into that shortly. The rights, they run indefinitely as long as you take care to maintain these rights and keep good records. How can your competitors try to strip away these ideas from you, or grab your own ideas? They can reverse engineer. And so there's something that we want to talk about that's a potential defense, and that's called a prior user right. So let's say that you have a product on the market, and then someone else comes up with something similar or the same, and then files a patent application and then sues you for infringement. Well, that's where you need to invoke the laws of the United States, which include prior user rights. Now, there are caveats to these provisions in the law, and we can, of course, assist you in identifying ways to mitigate that. But this is definitely something to keep in mind about developing products. And what if you unintentionally have something taken from you? Well, then you may be able to enforce some rights that you have. There's a scenario we call our nightmare scenario, which we talked about, is you're sued for something you're already doing. And one thing to consider is file one of these patent applications which are not published, like a provisional, and that'll keep something in your back pocket to protect looking forward. If you stay in the US as the only venue of filing, you can file what's called a non-publication request, and as long as the patent application is progressing before approval, it's not published, and then this can be withdrawn depending on what your business interests might be. But assess your competitive situation, and you can consult with us at any time. We have a standard form called a record of invention form, which can provide guidance and ask some legal questions to help you identify if you would like to either seek patent protection or opt for to keep your trade secret. And we even have a patent and trade secret checklist, which is similar to this chart, which can compare and contrast strategies. But keep something in mind. If you don't seek patent protection, you can't necessarily rely on your prior user rights. For example, patents that are first owned by a university may be exempted from the prior user rights defense. So you may not be able to take advantage of that. But I'd like to, at this point, we'll have time for a few questions at the end, but I'd like to pass the discussion to my colleague, William Cole, who's on the West Coast. William?
Thanks, George. I appreciate that. If we can go to the next slide. So I'm going to talk now about trade secrets. And what I'm going to say about trade secrets is applicable to any trade secret. It's not specific only to mental wellness or supplements or anything like that. But these principles are very important for anyone who wants to rely on trade secret protection. Trade secrets are not registered. They're like a patent. They're not granted. There's not an office in DC that hands out trade secrets. Instead, trade secrets are an operation of law and certain statutes. And you either fit the definition of this trade secret and can prove that in court, or you can't. That's sort of how trade secrets work. There's a federal statute called the Defend Trade Secrets Act. There's also, every state has a trade secret statute. As far as I know, I believe all 50 states have a trade secret act as well. I put uniform in parentheses because the state trade secret acts tend to be based on what was at one time a uniform model, but they've all made their own various variations. So each state is a little different, and you have to check your own state's laws if you are litigating the case under trade secrets in a particular state. But what is a trade secret? A trade secret is information. It's information that is not generally known or that is not readily ascertainable. Now, what does that mean? It doesn't mean generally known to the whole public, but it means generally known to the industry in which the information pertains. So, for example, in the area of dietary supplements, the question would be, is your information that you're claiming to be a trade secret, is it generally known, or is it readily knowable, readily ascertainable by the industry in which you're in? The information must derive independent economic value from the fact that it's secret. In other words, you have a competitive advantage of some type. You gain some economic value from knowing your secret, from knowing your trade secret, and having others not know it. Okay, so that's key. And then your trade secret must be the subject of reasonable efforts to maintain its secrecy. And that is often a problem. And we'll talk about that. If you go to the next slide. Trade secrets can be just about any type of information, a formula, pattern, compilation. I want to talk about compilation in a minute. It could be a method of manufacturing that makes your manufacturing process a little better or a little faster, a little more efficient than someone else's. It could be virtually any type of information that you derive a competitive advantage from that's not generally known. A compilation means that even if your trade secret consists largely of individual components that are all known generally, the way you've compiled those generally known pieces of information may be unique and may itself be a trade secret. Let me give you an example. Street addresses. Street addresses are not secret. You can drive it to my house and get my street address whenever you want. But it's possible that somebody could put together a compilation of street addresses, take an entirely public information, and put together a compilation that identifies the street addresses of a particular group of people across the country. That could be very valuable. It could be a trade secret. And so that's just an example of how even publicly known information, when compiled and arranged in a certain way, may have a trade secret value to it that could be protected. You can think about how that might apply to your own work in mental wellness supplements or functional foods. I listed some of the common examples. Some of these may be more applicable. Well, actually, these are generally applicable probably to almost any business, especially a business in the supplement space. But your suppliers, your vendors, their preferences, their your profit margins, your formulas, your algorithms, your software, if it's proprietary, your recipes, all of that can be potentially a trade secret. If we go to the next slide. We've already talked about the idea that even publicly known elements can qualify as a trade secret if they're combined in a way that's unique and not publicly known. But really the bugaboo with trade secrets, I think, and the greatest challenge is often being able to establish that they are actually the subject of efforts that are reasonable under the circumstances to maintain their secrecy. What I often see in litigation is a company after the fact, when its information has been misappropriated by a competitor, the company then after the fact is looking back and trying to show the steps it took to keep it confidential. And often those steps are hard to find because the company, even though it knew the value of the information, perhaps in the press of business, in the rush of getting everything done, just did not take the steps necessary to make a really rock solid case that their efforts to protect the secrecy were reasonable. Typical ways to protect the secrecy of a trade secret would be confidentiality agreements, NDAs. Those are critical. It's to restrict the scope of who has access. If your trade secret this is sort of similar, not as extreme, but similar as to the idea of classified information in the government. We all know from spy movies about need to know, who has a need to know the information in a spy movie and only giving it to who really needs it. There is a similar aspect of trade secret that it's best to only let those who need access to it within your company to have access and to deny that access to other people. Now, it could be, though, that in your company, a wide scope of people need to have access to it in order to make use of the trade secret. And that's fine if that's the case. But again, someone later, a court, is going to be looking at who you give access to and why. And so it's good to keep in mind the scope of who has access. You can restrict access. A lot of the cases talk about files being kept in locked cabinets. I think that's a little anachronistic. It still exists, I know, but it's probably most often now files are kept behind password protection on computer systems and in databases. But do you have password protection? Do you have things under lock and key if that's the way your files are stored? To restrict access to only those who you want to have access. And then the last point here on this slide is follow the procedures you set up. I have to tell you, and I think anyone who works in any organization understands how this happens or why it happens, but almost every organization has policies. The extent to which those policies are followed or applied varies. And it's not enough to have a policy to protect your trade secret. It is important to actually follow the policy and procedure to protect your trade secret. For instance, confidentiality agreements may restrict somebody from making disclosures. Do you enforce the confidentiality agreements? Do you take action when somebody doesn't follow them? That's just an example of down the road when you're in litigation, that can become an issue. So it's important to think proactively about what is your unique competitive advantage that you derive from what information, identify the information, and then identify the steps you want to take to keep it secret that are reasonable. The case law is clear. The steps to protect the trade secret do not have to be heroic. They don't have to be unreasonable or extraordinary, but they need to be reasonable under the circumstances. And so it's important to think about that in advance and then follow the procedures once established and where necessary to get legal counsel to help you come up with those procedures in the first place. Next slide. If you have any questions, you're free to contact us at any time, of course. And then if we can go to the next slide. And I think at this point, we have time if there are any questions or comments.
We do. Thank you, George and William. Anybody who has questions, please post them in the Q&A box, and we have a few minutes to get to those now. I want to just kick off with this question that came in that is really great. the question is, transparency has become pretty much standard operating procedure in this industry. It's expected up and down the supply chain. So how can companies protect their IP and their trade secrets and maintain transparency?
Well, from the trade secret standpoint, it depends on what transparency you're talking about. If you talk about transparency with other members of the supply chain, then that's going to have to be protected by NDAs and confidentiality agreements. If you're talking about transparency with the public, then it's just a fact that any transparency with the public, once the information is publicly disclosed, at least that information is not a trade secret. Now, you may have we talked about a compilation trade secret that exists of many parts put together in a novel way. The fact that you disclose one part or two parts doesn't necessarily mean that you've lost the protection. But just remember that once the information you're claiming is a secret, once it's publicly disclosed for any reason, for transparency, for good reason or bad, once it's disclosed, it's not a trade secret because now it's generally known.
Yeah, I want to ask, I mean, you've made, oh, I'm sorry, go ahead.
Yes,
George.
oh no, thank you, Maggie. And from the inventive side, from the patent side, just keep in mind that we're all interested in perhaps natural and sustainable presentations and statements, but be careful when you make a statement. It could have an impact on your invention in terms of intellectual property, and that can be used against you unless, and I don't mean to be a broken record, you can file a patent application under various circumstances and maintain at least those the rights are available to you to develop. But one must be careful in making those statements, even for a promotional use. Keep them broad, but the more specific you go, you may be locked in as far as a disclosure, and you may lose the trade secret aspect at that point.
Excellent. So I think I was going to say you both made it really clear that trade secrets are only good if you keep them secret. What are some common ways that companies trip up things that just blindside them? They didn't realize they were letting it out there. Any common mistakes that you can flag to help people boost their awareness?
Well, I think that sometimes different departments in the company I've seen have different motivations. They're all pulling the same direction eventually, but they have different thoughts in their mind about how to go about their business. So for example, the side of the business that might be creating the trade secret is very aware of the need to protect it. For perhaps the sales side of the company, the marketers, they may be out saying things to people in presentations or pitches to sell a product that are helpful to make a sale, but inconsistent with protecting some trade secret information. So I think it's important that there be sort of a same page approach to, okay, what can be shared publicly and what not, because people in one department may assume it's okay for their purposes to share more than another department may be comfortable with. The other issue I said is also, just as I mentioned, is just not to be a broken record, but is just following the procedures you actually have. Almost every, it's a common problem with contracts in general, that people write a contract and then the course of dealings becomes comfortable and nobody really refers back to the contract anymore. They just refer to their trust with each other. That's a problem when it comes to confidentiality agreements or NDAs. We have employees, perhaps key employees you sign an NDA with, and then years go on, you develop great trust and reliance on the employee, and no one's really referring back to the requirements anymore, perhaps. But it's important that we follow through in protecting the trade secret by insisting on the obligations of those confidentiality agreements.
And let me just jump in and make a comment on the intellectual property side. Again, the marketing department might be excited about promoting a new product and makes a broad statement. Those can be damaging to patent rights or trademark rights if they're made public or shared at at trade shows. So you might want to have a policy in place, or think about having a policy of perhaps filing provisional applications so that you have some patent protection in place that can mitigate those statements later and provide a backup. You don't have to commit to major expenses at that point and go all in, but it at least provides a basis for protection later in the event that that's raised during patent prosecution or even litigation.
Excellent, thank you. Another question here is, understanding that leaks do happen, so non-disclosure agreements are critical to maintain and enforce trade secrets. But when you have something good, people want to get at it. So the question here is reverse engineering legal?
Reverse engineering is legal if from a trade secret standpoint. I'll speak from a trade secret standpoint. There's nothing wrong with reverse engineering as long as you didn't rely on your trade secret to do the reverse engineering. They can't take your trade secret as a head start to their reverse engineering. But if they're genuinely reverse engineering a product from publicly known information, that typically is not prohibited in the trade secret context.
Right, and it goes according to the maxim of, that all in at least in patent law, that all inventions are combinations of previously known things in some sense. So you're going to expect your competitors to try to figure out perhaps your formulation or establish something similarly. So reverse engineering can occur, and subject to the trade secret provisions, as William mentioned, it's not prohibited to do the scientific investigations or the clinical investigations to not only find out what you may be doing in-house, but to improve upon it.
We have a question here that came in. George, you said something early on in the talk about genetically engineered GMOs and those being patent eligible. And the comment is, this is a hot button in our industry, and we know that genetic engineering is going on and with some supplement ingredients. But the comment is, GMOs are a problem for our industry. So how do we get around that? With the products that are natural, are those at a disadvantage? What's the deal there?
Right. Well, there may be a roadblock based on the laws relating to eligibility of natural genetic materials, but formulation many times can be used to overcome those restrictions. And so we try to help our clients and developers take a good look at ways they can develop new formulations and perhaps use excipients or known acceptable ingredients to be an advantage, particularly for consumer, human use, pet use. So there are ways to push against that. And we understand the sensitivity to GMOs. We're not implying that you always have to take that route. We should talk about formulations more, and we encourage our clients to contact us about that. Excellent,
thank you. And I also want to thank you both for sharing the record of invention form with our attendees, and that can be accessed on the Amin Wasserman page on naturallyinformed.net. And also you can reach out, and they'd be happy to help you as well. So thank you both, excellent talk.
Thank you. Appreciate it.